Was starting and then just going a little bit longer. So we're actually going right now. Because we may go longer.
Okay, I'd like to, Declan, take your seat. We're going to have you give us some input on this very exciting topic of commercialization in outer space. So I'd like to welcome all of you to this morning. We had this great panel on space law, and Desiree and I are founders of the Academy for Future Science, which is a futurist organization. It's connected also with the UN, with the ECOSOC Committee, the Economic and Social Council. We also work with the International Space Development Authority, which is the shepherding to bring not only ideas, but people, commercial enterprise into outer space and basically lay the new foundations of what I will call the movement from humankind to spacekind, the ability to accept, as it were, a whole new frontier of development. We all know that space has changed from the political situation of the Cold War period, but space is now being recognized as the essential tool for not only politics, but economics, society, issues of safety and security. The whole, we would call, mechanism of the innovative geome is anchored in space, where we go from here in terms of building habitats. It's also used for knowledge access, information at any time from any place. It has the flow of goods worldwide. It represents an omnidirectional frontier. And of course, we're privileged to be here with our dear colleague from South Africa, Mr. Musk, and his SpaceX Falcon rocket Dragon capsule, and you can see it on exhibit just outside the Space Convention Center. I would encourage all of you to stand next to it to get the thrill of basically being part of the first commercial enterprise that took us to the space station. And he represents really what we would call a technological wizard, or a new type of Marco Polo for the next generation of space development. Besides this, we've had Sir Richard Branson and the Virgin Galactic Enterprise take us up with the White Knight 2 program. You saw a little bit of this through the work of George Whiteside and others. What we're interested in is not only the spin-offs of the Virgin Galactic White Knight system, but also the new generation of small satellites, and also his ability to build spaceports throughout the world. He has one connected in New Mexico, just south of Los Lunas, where we have one of our bases of operation. And our colleagues also working with Ames Universal are working in tandem with Richard, trying to, as it were, create a new commercial network throughout Mother Earth. But the crucial question is, what space laws do we have on the books? Are they outdated? Are they basically inhibiting our commercial development? We all know we have, in addition to the Outer Space Treaty, the 4 other treaties that are the nuts and bolts. Fortunately, the United States never signed on to the Moon Treaty in 1979, which has only 14 signatories. I think the majority of spacefaring nations recognize that that would be velvet handcuffs around our scientific enterprise. But we do have these outer space treaties. What do we do with these treaties? What is our role? And of course, we feel that there is room enough for legal nuances or a whole new ontology of legal science, and this is so important to address. Who makes international space law work? And we heard from our panel of experts this morning, what do you do in a situation where there is scientific competition over an asteroid or over some other celestial object? There are really 4 working groups. 2 are connected with the United Nations Office of Outer Space Affairs, the Committee Services, and the Research Section. 2 are also working out of Vienna, Austria, with the Committee on the Peaceful Uses of Outer Space. This is the Scientific and Technical Legal Committee. And our work with ECOSOC is to offer up scientific position papers that will lead to the decision-making as to who is right, who is wrong, in terms of white hat scenarios. But there's more to this than just 4 committees. there is the, shall we say, challenge to train a whole new generation of legal scholars throughout the world. The Outer Space Treaty, as we see, sought to assure that the sending of objects through space will be exclusively for peaceful purposes, and second, for the use of space carried out for the benefit and in the interest of all mankind. And these are nuances. What is the benefit of mankind? What are the interests of mankind? What are scientific endeavors? How are they defined? In fact, even scientific truth is up for grabs, according to some experts working with artificial intelligence. This falls into what we call res communis, a Latin term for common property. And so outer space is seen basically as the ocean of opportunity for all countries who do not stake out as stakeholders property on the surface of the moon, Mars, or other celestial bodies. Some of the newer laws that have been developed include the principles governing artificial Earth satellites for international direct television. And here we have in section 33 those situations whereby broadcasting situations might be, shall we say, in favor or skewed to one power as opposed to another. Principles related to remote sensing of the Earth from outer space. I worked in this area with Jet Propulsion Lab and remote sensing technology. And often the cry from third world countries, developing nations, was you're taking all this information from your satellites. Why don't you pony it over to our scientific experts, our geologists, our environmental scientists? And of course, we have then the Declaration on International Cooperation in the Exploration and Use of Outer Space. I mean, that pretty much speaks for the obvious that has to be, shall we say, put into the advancement of the envelope, allowing all nations to have an equal hand and opportunity. But what is equity in this situation? Does it mean that everybody can stake out situations without, as it were, a global ethic, a biological ethic? The Reagan administration passed something that was very important in '84, the Commercial Space Launch Act, establishing through the U.S. Department of Transportation a regulatory agency process that encouraged, facilitated, and promoted private commercial space launches by developing licensing requirements through consultation with other agencies. And of course, this is one control mechanism, licensing on Mother Earth, to control who does what in outer space. We have under the present administration of President Obama the 2010 codification UIC Title 51 U.S. Code, which states, in effect, to enact certain laws relating to national as well as commercial space programs as title laws on insurance and indemnification, international cooperation, microgravity research, and this is what I want to highlight, pricing policy for commercial and foreign users. So we have basically an economic ways and means that may give some privileges that others do not have, depending upon what area of economic privilege. This does not change the laws. It simply provides for a unified national model through which all countries can work.
So I'd like to pick up at that point because we're talking about insurance. One of the reasons for insurance is what you see here. Many of you are familiar with it. Maybe some of you put it up. There's more than 3,000 working satellites, mostly in low Earth orbit, but there's actually about 9,000 satellite fragments. I'm going to show you a Google animation that was done, taken from the NASA. You can see the real-time position of about 13,000 satellites. Of course, they're not all satellites. Some of these are fragments and debris. And I appreciate the question from that man earlier today, even though I like what Virgin Galactic is doing, when they talked about putting more and more satellites up, I mean, someone has to take responsibility for them a little bit more than what's going on today. So you can see this is the farther it reaches out from the low Earth orbit, but we're being quite surrounded. I'll go on because our time is short. Who monitors this? Satellites are tracked in the U.S. by the Space Surveillance Network, and that's what it does. It's looking at about 24 to 25,000 different objects, and a lot of them have fallen into unstable orbits, incinerated, of course, thank goodness, during re-entry. And Russia leads the list of the greatest amount of decayed debris, about 10,000. Here's just a quick list. This is a 2007 NASA analysis. You have the payloads on the top, and you have everything else going on from all the different countries underneath it. Again, payloads here in terms of decayed or beyond Earth orbit. Most of these are beyond Earth orbit in the payload category. And it's just quite a lot of stuff that we do have to take responsibility for. I think what's really exciting, though, is the Swiss decided to do it. What are the Swiss known for? Clean, neat, and making money. So what did they decide to do? They put up 2 satellites in 2009 and 2010, and they said, well, we're not going to just let them go to, decay. We're actually going to create a Clean Space 1, and it's for about 10 million francs, obviously doing it for fairly cheap, and they plan to launch some things in about 3 to 5 years. So it'll be really a garbage collector in space. I think that's really exciting. Why is it important? Because, of course, everyone knows February 2009, you had the Russian satellite Cosmos 2251 that hit in space Iridium-33. I love the Iridium Corporation. I was really upset that that happened to them. But that's just what does take place. They had really bad luck, as all of you know. But it broke into about 700 pieces, and even people in the International Space Station had to take cover in the Russian Soyuz rocket. We gave some of this. We work occasionally in developing countries, Mexico, Brazil, and in February of 2012 of this year, a spherical object weighing 66 pounds, about a meter in diameter, fell in a little town of Anapuras. I'm going to show you this for a minute because it's so interesting. You can't hear the sound because we don't have sound connections. You would think it's just like some sort of comet or asteroid, but it has this little metal thing on the top. Some of you can see. So it really has been identified as a falling space debris that made it into our atmosphere. So you can see him holding it, and later on they kick it. You can watch this on YouTube. He's actually holding the very top part that it'll come up in a minute. It's a little metal spherical circle that's still stuck on the top that shows that it's actually man-made. And this is them taking pictures of it. Give you another minute on that. Anyway, there is this little ball that has a spherical object on top of it. And it makes noise. They clang it, they move it. So anyway, just very interesting that that landed there. Now, the Outer Space Treaty, which everyone said is so important, sets up the responsibility that each state is responsible for their national activities. And that's consistent with the law of the seas, which is why boats have flags. They're responsible, no matter who's on the boat, for taking care of what's in it. Also, Article 2 of the Liability Convention, which reaches out into outer space, says a launching state shall be absolutely liable to pay compensation for damage caused by its space object on the surface of the Earth or to aircraft in flight. So countries are starting to look up and take serious this reality, and every country practically that's really a spacefaring nation now has set a minimum insurance level for what, and I know someone mentioned in the conference yesterday that the insurance is the hard part, because they are needing to do that. UK, in its Outer Space Act in 1986, even set up 100 million pounds, France 61 million euro, and so on and so on. You can see this going down the list, because and then after that, the government is liable to cover that reality. Now, something all of you who've been listening to the conferences know, that it's not just government, and that's what we're saying. It's now people, it's SpaceX, it's Virgin Galactic, and it's also James Cameron, and perhaps Google's chief executive Larry Page and its executive chair Eric Schmidt, that plan by 2020 to be out on the asteroids to actually mine. And there are companies called Planetary Resources, and in the next 18 to 24 months, they claim they'll be launching a series of private telescopes that will search for the right asteroid targets. And what can they get from there? They can get minerals, they can get water, they can get fuel and oil, and natural resources, some of which are also non-renewable. So they are moving ahead, regardless of what the Outer Space Treaty tells them. And as Declan O'Donnell will say, let someone sue them. because that's the best way to move laws forward. We'll talk about that in a few minutes. Dr. Hurtak?
Well, we recognize that the Outer Space Treaty not only prohibits the claiming of territory, but it has a psychological mechanism that's somehow part of the older generation that does not see the adventure of space. And certainly we recognize through our colleagues at NASA and other strategic players that the old legal regime prohibits really also legal entities and spin-offs, of course, which would be enormous. And this is a feeling we had also from our friends in Brazil and South Africa, younger companies wanting to get beyond the UN treaties that would be more centered for commercial exploitation of space. And this is why we've been working largely in Brazil, which is a new superpower coming up. And the impact that we've had from them, even with the Russian materials coming down on their country, is that they want to look at the legal nuances and change really the treaties. Three options to change the concept of common property are withdrawing from the Outer Space Treaty, 2, amending the Outer Space Treaty to try and work around the res communis doctrine and shape the treaty more in line with present-day global realities, incorporating what some will call first come, first serve, or extra commercial activity as applicable to some instances. Again, this is what Declan and I feel is so important. And we are trying to do this through our published papers, position papers, and text. And 3, there's also the possibility of highlighting domestic space policies which could evolve into more multilateral agreements with other countries regarding the use of space. So there are open-ended flexibilities that are at hand. We have a whole new generation now of multilateral and bilateral agreements between countries. This is of great interest, particularly to the non-aligned, the South Koreans, in agreement with the peoples from the Ukraine, aimed to promote mutual beneficial scientific technologies, industrial, economic, and other cooperative projects related to peaceful uses of outer space. They have an implementing agency. They're working also with the National Space Agency in the Ukraine, and through joint committees. We see this taking place also with other smaller countries. There's also the aspect of going ahead through the intergovernmental agreements, often referred to as the IGA. This is an international treaty signed in January of 1998 by 15 governments involving this space station project. We'll get more to this later, but the space station can be really one of the alternative strategies as being a place where conflict resolution can take place. In addition, there are 4 memorandum of understanding and several bilateral agreements on the books that you can look at our papers that are posted. If you look at the space station, this marvelous city in space that's being put together, we can see the components of the major contributors: United States, Russia, Japan, Europe, Canada, Italy, and Brazil. The question arises, who owns this space station? The Intergovernmental Agreement allows the space station partners to extend their national jurisdiction on outer space so the elements they provide are assimilated to the territories of the partner states. In essence, everybody owns the space station that has been part of the process. As I said before, we're moving into a whole new definition of going beyond the nation states. We're going into a whole new ontology of what is called the scientific ways and means, the operating procedures. And so we must go into a whole new direction with space partners who will be operating in decision-making situations in space. The basic rule is that each partner shall retain jurisdiction and control over the elements it registers and over personnel in or on the space station. So we have basic situations that would allow for a space court to be put on the space station made up of astronauts, scientific experts, who could decide in near real-time situation whether the situations of competition. The Intergovernmental Agreement establishes the cross-waiver of liability, which prohibits any of the 5 partners or their related entities to claim against another partner for damage or damages sustained as a result of the International Space Station activity. Each partner is required to implement this obligation in the contracts with its own contractors and subcontractors. So again, we have now a decision-making process to refine the nuances of language, space jargon, if you will, and to look more clearly at multilateral situations that can be reinforced either through licensing agreements and or other situations that may take place literally on the space station in the future decades.
So I'm excited about SpaceX and Virgin Galactic. Of course, SpaceX is more government contracts, Virgin Galactic, but look at how many other suborbital space tourist organizations. And the man today, of course, said, go visit the Mojave. You can see some of these. Space Adventures, Virgin Galactic, Star Chaser, Blue Origin, Armadillo Aerospace, X-Corp Aerospace, Rocket Plane Limited, and European Project Enterprise. All these different companies are now moving into suborbital, not orbital, of course, but suborbital space tourism. But it's getting exciting. And so what does that really mean for space law? All these scenarios are being thrust upon an archaic system that really has not been majorly updated since the 1960s. So what about going to Mars? Since we're all interested, what laws are needed to environmentally protect Mars? And at the United Nations, the new canon of space law is only being discussed, not really moving forward. And they're looking at what I think many of us agree with, which is the commercial activity is applicable in some instances, and I'll pronounce it extra commercium. And some NGO delegations want to establish areas on Mars that are legally, environmentally protected zones. So you have the protection in some areas, you have the commercialization in others. And so what do you need for that? But you need a committee to arrange what areas come together. So a committee would have to be set up, probably with the United Nations, where somewhat every country could be represented, at least every United Nations country could be represented, not only in the committee, but also somewhat with their experts and advisors. This is not an impossibility. The question is, what if life is found on Mars? I love the panel yesterday. I know many people thought it went back and forth a little bit too much, but it's not new. Andrew Haley in 1956 wrote Space Law and Meta Law, a Synoptic View. And I think it's just exciting that we're even talking about microbial life on Mars. If you would have gone back to 56, they really thought he was nuts, probably, that there wouldn't be life anywhere but here. So what was his idea? A common thing. Do unto others as you would have them do unto you, or what he later redefined as the stark concept of absolute equity. We all are working together. So if life is found on Mars, do we send more probes to investigate it? That was the question last night. Or do we put up a do not disturb sign and never go back? Whatever we do, we should be bound by the principles of responsibility and international accountability to treat life in outer space with the same dignity accorded to life on Earth. So we look at what happened even with the Indians. This is, as Stephen Hawking said, if we even had contact with some alien race, what would we do? Chances are, go back to the way the Indians had. Well, we took over that it was all common property for all of us. So we liked the res communis, and we used it for ourselves. Later on, we divided the Indians into this extra commercium where some commercial activities were going on in other places, and we gave them reservations to live in others. The other idea, which is maybe that of many enterprising scenarios, is this ex nullius, or first come, first serve. If we're there first, and maybe the life doesn't stop us, microbial life, why don't we just take it over? So these are all concepts that have been used and looked at and are really the three bases for choices of the new space law. So Dr. Ernst Fossen wrote in Relations with Alien Intelligence in 1970, he proposed meta law is the entire sum of legal rules regulating relationships between different races in the universe. It is the first and basic law between races, providing the ground rules for a relationship if and when humans establish communication with or encounter a microbial life somewhere else in the universe. The main point, and this is probably where we all stand, is to avoid mutually harmful activities. And with that, we conclude.
Yes, I'm thinking in the background what Jerry O'Neill said, the whiz kid from Princeton University. Are we going to face a new generation of pirates in outer space? Or will we have mechanisms to enforce our treaties? Again, the vastness of what we're finding on Mars in terms of the water content is truly amazing. John Bradenberg from NASA was one of the first that postulated there was vast subsurface water systems. We're now seeing through Phoenix and other projects and probes the reality of that statement. We have also the harbinger of food factories, subsurface food factories on Mars. We know that we can build habitats that can sustain small groups, and this can grow in large numbers by the end of this century. Fantastic possibilities. So are we going to have a new sample system of laws, or do we expand nuances of, should we say, the terms of the space laws already on the books? In relationship to Mars, mineral and other natural resource activities, should they occur, the parties will acknowledge, or should acknowledge, to A, protect, I'm giving this as an example, the Mars environment and dependent and associated ecosystems. B, the possibility with respect to the legitimate use of Mars habitats, namely the expansion of the zones of activity. 3, maintain, or C, the zones for microbiological sampling, so there's no contamination by bringing these samples back to Earth. And this is kind of a buzzword concept. D, establish a court system on the International Space Station that addresses integrated business, operational strategy, and scientific competition right there on the space station. The space station can be moved. It could be put into orbit around the moon. It could be used as a launching point for the first generation of a whole new court system, truly by outer space experts who are there to make near real-time solutions. Future legal strategies thus must consider the indispensable role of science in clarifying and resolving planetary prerogatives or guidelines for activity. However, scientific theories and discoveries alone are not sufficient to influence policy and a close collaboration between scientists and a new generation of space law experts. We have to have what is called expanded values that bring together the commercial ideas as well as the sociological ideas. Innovation is accelerating, requiring a holistic mapping and meaning for exobiological realities, artificial intelligence, space-based or quantum technologies, quantum networking, what is called blended values of technology and sociology, and pure social return on investment. We have to look at interactions between public and private sectors on space activity in terms of hosted payload gain traction, which has occurred now in the last couple of years, NASA awards, contract funding to various commercial space adventures. The example of Australia investing in national broadcast networks as a model that can be carried forward into other directions, and of course the European Space Agency looking at the area and space economy and making other proposals. And then we're looking at also multilateral sharing and negotiations and mobilizing data and information that must be connected with the world body of legal stature and background like the UN COSPAR Committee on Space Research, so that laws and protocols issued from one global dimension of planet Earth to other global dimensions of planet Mars. Negotiation requires strategies developed that must not only employ customary diplomacy, but also must take into account the expertise of the EPA and NASA, the European Space Agency, etc., and strategic partners, including environmental NGOs on the ground, that we saw recently when we spoke at the UN Summit on Sustainability in Brazil, the importance of what Robert Watson said, that the scientists working on the ozone problem back in the 80s, that we need to have an integration of people working with many disciplines, a cross-cultural approach in science and industry. In summary, we must ensure a higher public awareness.
And so with that, we'd like to invite, if Declan will come up for just a minute and maybe give us a few final words for the thought today.
Particularly in the sense of litigation. Declan, do you feel that we can use the situation of space debris as launching a new type of litigation situations from major countries that have, shall we say, spoiled the lower atmosphere, that would, shall we say, bring us funding for some of the more important projects, or help, as it were, the debate as to who's on first base?
I'm a trial lawyer, so I vote for that, if we can go to court in any way, shape, or form. And I say that advisedly. In not only our country, but in every country, there's one point of magic that works in society, and that's called the gavel. It's pretty simple. You're standing there, and all of a sudden everything's over, and the judge looks at you and says, blah, 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 pow. Okay, and everybody leaves. That's it. It's all over. You're bound. You're stuck with it. There's nowhere else to go other than to another court where you can get another gavel. And the gavel is important. It makes people understand that something has really happened here, even though you can't see it. Now, we had this idea come in our group with Brad Blair being the leader of this group and this committee on space debris. And it evolved into a concept that perhaps we could actually make a lawsuit come forward under the liability treaty to have the nations who put the stuff up pay to bring it down. And so the first leg of that litigation would be to assess damages to the countries who put space debris up. Then the second part of it would be to have hearings from contractors who could receive a gavel that they are now in charge of taking it down, and nobody else. It sort of defines the problem legally and therefore socially. And then we can run with it for, what, 5, 10, 15 years if we have to, but have some confidence that it will be solved. I have an ability to speak for half an hour on any subject.
Okay,
I know our timeline is short, but what do you think about what we discussed recent times about eventually putting a court system on the International Space Station?
I don't know if that belongs there, but it needs to be in space. And that's not our business to pick. I think the scientists will tell us where we're going to be. And without a court system, you're going to have a difficult means of resolving disputes. But with a court system and a gavel, there's one nice thing about it. You know when it's over.
That's right.
Okay, well,
The final footnote is we've just published the first textbook on space law in Brazil at the Academy of Uno Est in the state of Santa Catarina in South Brazil. The law faculty has adopted this is the first time in all of South American legal institutions that we have a course of space law studies. A text that is now being used in Portuguese will be in English eventually, and I promised Declan that we'll be using his writings also for our position papers at some of the UN committees that have an interest with NGOs. Again, we thank you for this opportunity to...
And just a final word, if you know law students who want to go into this, there's a facebook.com space moot, and the International Law Society, or Space Law Society, has once a year a gathering from all over the world of people, kids who come together who are appointed to then fight each other out in the summertime in various parts of the world. So that's the space moot. It's the mock court.
So keep looking up to the stars, at Astra, get behind the commercial enterprises our country was noted for, put NASA back on track, and inspire a younger generation of engineers, space lawyers, because we're going to need what it takes really to argue these cases in space and on Earth. Blessings.
Next person. As Declan said, we can talk for another half hour if no one's here. So.
It's supposed to be Erickson. So it's not Erickson. Q&A. My name is Q&A.
Yeah. Okay. So. questions and answers. Declan, why don't you? Oh, he's already talking. Is Erickson here yet? No? Okay, when he walks in, we'll stop talking, but if there is some questions and comments.
You're based in Brazil?
No, we're actually based internationally. We're based here in California as well. Yeah, but we work. Erickson's not here yet, right now? Just let me know. Okay.
I
Someone
guess
let me
what
know.
I'm
No, it's okay. So
wanting to emphasize, though, is the young people that we've talked to at the universities throughout the world is somehow the
oh, no, I know.
ability to get into the space program will require using valuable materials in their own backyard. The South Africans and the Brazilians in particular are interested in taking this step into outer space and making use of the commercial side of what Art recognized this morning when he said socialism is practiced according to space law in the States, capitalism in the Soviet Union or the new area of the Russian Federation. We have to look seriously at what inspires young people throughout the world to be involved in the whole enterprise of moving from humankind to space kind with no set limits, no umbilical cord to the old political or economic models that have caused, shall we say, so much of a valuable loss of time. And to that end, Desiree and I have lectured and been members of various faculties throughout the world and have worked, of course, in conjunction with strategic partners to try to keep the, shall we say, free enterprise system alive and well in other parts of the third world.
But I think the bottom line on everything is that we really are growing up, and I think the landing of the Mars Science Lab is one key section of that, but also the whole SpaceX that took place in May of this year and what's going on next year with Virgin Galactic is all showing us things are changing and we all need to change. Just like we've moved from almost TV, I guess, young people to iPads and iPhones, the whole idea of what's going on in space is now changing as well. You have a question?
It would seem to me that in order to cut loose those umbilical cords, like
Yeah.
you mentioned in this respect, one thing that needs to be looked at is the fact that the Moon Treaty is still a treaty in force. It denies property outright and gaining signatories every year. It's impossible to move forward with any pro-property amendment to the Outer Space Treaty because it requires unanimous consent within the United Nations. How can you have that when there's these 13 countries tied in with the Moon Treaty?
Well, I really like what the man said today that, you know, just go ahead and do it, and I think that's what we feel. And see, you can get away with certain amounts of things. Did you hear the talk this morning on space law? It was very, very good because there's a professor, and he said, you know, it's not stopping commercialization per se. And at some point, they might try to stop it, and at that point is where you fight it and where you come forward. And I think that's what, like Larry Page and James Cameron are doing. You know, move ahead. And I think it's really interesting that, you know, they're not waiting for, it reminds me of the Genome Project. Like the government was going to take another 5 to 10 years, and Venture came along and did it in 9 months. What happened in 9 months? Who knows? The government did it in 9 months as well because they knew they had a fight with Venture, and Venture would own the genome code if they didn't get there at the same time they did. So it was a 5-year funding that they got down to 9 months when they said they barely could do it in 5.
So Venture could bootstrap, and with the consortium of computer scientists from the area of Irvine, California, he could, shall we say, outflank really the traditional situations. And of course, to the great embarrassment of the government in the year 2000.
Several governments, actually.
At the Science Summit, of course, you had both the traditionalists as well as the futurists looking at Venture as really being the prize. Elon Musk is really the Venture of this present generation. We salute him very much because he's the flagship that's going to carry much of the youth of the world. And this is so important that he, coming from South Africa, realizes advantages here that people don't because their heads are too much in the book of legal terminology without looking at the nuances and the shall we say, appraisal of the situation for the benefit of all.
Yeah, when the next speaker's here, let us know. Thank you.
Apparently, Brian Erickson isn't here. I guess his name tag's still there. I guess he hasn't registered.
Okay, so we'll keep going. We can do a whole round on yeah, get Declan. Actually, go get Declan. Tell him to come.
Or catch their second.
The reason we mentioned Declan is we worked with Declan a lot, and we did a paper in South Africa at one of the major summits dealing with the theme suborbital private launch quote unquote, may require a legal situation. We recognize that we might have to fight in international court systems some of these laws and regulations. Yes?
If the satellite, let's say it's U.S. and it's military, and a piece of debris falls into a country, does the U.S. have a right to go and pick up that piece of debris? Can it claim it back?
Well, this was the situation with the Russian Cosmos satellite that came down in 1979. I was in Canada, and it actually fell in Indian territory, but the Canadians assumed the responsibility of going in with American helpers to retrieve it because of the nuclear materials, or what was thought to be nuclear materials, on board. And it was a situation that, shall we say, reopened the debate as to who is on first base, who gets the privilege to go there. And here issues of sovereignty rule over legal situations as to who is next in line to make, as it were, the return of those materials to the country that launched into space to begin with. But the Canadians took, because of the precariousness of the nuclear materials, the decision to go in, even into neutral area of Indian territory, retrieve, share with American colleagues, and give back to the Russians a report.
Is there a difference between military and civilian?
There is a difference, but in terms of legalese, you have lasers that are used in situations that could be used for weapons as well as for analysis. So we have dual use technologies. And this is where you have to have the UN committees, or you have to have international law and scholars debate the issues. Can certain laser systems be powered up to be used as weapon systems? This gets into the refinements of why we have space law. Declan, please join me here, because he's the source for the experts. And let's talk a little bit about what happened in South Africa with the paper on suborbital launches that might require a legal situation.
Well, the sidebar on that one's more important than the story. We've presented a paper, and I delivered it, I think, didn't I? Yeah, anyway, at the end of the paper, a lawyer stood up and said, Mr. O'Donnell, I know you haven't been around here as much as we younger people lately, but see, nobody in this room agrees with anything you said. And I said to myself, how do I answer that one? And so I didn't. But the newly elected president of the International Institute of Space Lawyers, which I've been a member of for about 30 years, said, I'll be out in the hallway. I have some tickets for the banquet tonight, for the lawyers' banquet. And so I said to my son, who's about 6'6", Declan, let's go out there and get a couple tickets, because I don't think we have any. And we went out there, and this guy who was the president was the one who was telling this lady what to say, apparently. And I said, well, I'll take 2 tickets. And he said, no, we're sold out. We don't have any. No more tickets. And so while I'm standing there, another dude comes up and says, I only need 1 ticket. And the guy says, okay, that'll be $30. Here's 1 ticket. And so I looked at that, and another guy comes up and he says, I need 2 tickets. He said, that'll be $60. There's two tickets. Another guy comes and says, I need 4 tickets. And all of a sudden I said, look, I don't want to hit you right now and embarrass you here in the hallway. But why don't you meet me in your office tomorrow morning at 10 o'clock a.m. I want to talk to you. So at 10 o'clock a.m. we walk into his office, including my son with me for my protection. And this guy jumps up and says, oh, here's your 2 free tickets. I'm so sorry about yesterday. I was all wrong. I didn't realize you knew what you're talking about. And what we did talk about was this new space and legislation passed in the United States encouraging commercial space. And the problem is that it does not abrogate or eliminate any of the treaties or any of the laws that grew up around the treaties, including statements and resolutions in the United Nations. And JJ and I felt that it would be a good idea to warn new space people that there are limits to how far you can push this concept of, quote, new space. It is not a good idea to sue everybody unless there's no other solution. But we thought that giving a talk that sort of warned people that there would be a problem, or could be a problem, would be a good idea. And we also suggested in our paper that a way to guard against you approaching those limits is to have a declaratory action litigation event before you take off with lots of people on your suborbital airplane and get a judgment in your favor or against you. And if it went against you, you could reevaluate very quickly whether or not you really wanted to take off. And if you had a judgment for you, it would be precedent. And then if it turned out that everybody else was liable, you would not be. So the use of a court system is pretty important in many ways, but in the outer space area at this juncture of our history, it might have these additional important ramifications.
Other questions? Yes, in the front here.
So I just wanted to ask, some of you guys here have probably heard of the Law of the Seas treaties. I know, Declan, you have. And the thing that came up with the Law of the Sea Treaty that we thought, we thought it governs international waters to some extent through the UN. It's a treaty for the international waters, and that might carry into space. And in that treaty, they talked about things that basically gave the UN sovereignty. And I wanted to just throw out there, if the UN tries to take that same kind of approach, possibly towards space, towards sovereign, maybe the UN having sovereignty in space or something like that, some type of thing. What can we do to help prevent that? And what can we do to just prevent that kind of behavior, if you will, transferring space?
Well, I think Wesley would suggest that perhaps the best thing we could do right now would be to prevent the U.S. Senate from signing up for and ratifying that treaty.
It did. It's blocked this year.
It's out now?
Yeah, I got a letter from Isaacson, from Johnny Isaacson.
Okay, good.
No more this year, but it'll come back up.
Yeah.
But I was just thinking, if the UN tries to do the same kind of thing, possibly even for space, even though the Law of the Seas Treaty doesn't pass, but if they try to make some other kind of semi-different approach in the space.
Well, I think the Law of the Sea Treaty will be back. It doesn't go away very easily, and I must say that America signed it in 1991 when Bill Clinton was president. And the trickery that got to have him sign it was printed in an article in the Ohio University Law School journal. And it said as follows, that President Clinton agreed to a bargain, and that was that the promoters of the Law of the Sea Treaty would allow America to run the authority of the Deep Seabed Authority, and that would be the trade-off for America, for him, President Clinton, signing that treaty for America, okay? And then he signed it, but as soon as he was not president any longer, America was evicted from that position of management. So it tells you that these people are just hell-bent on getting what they want. And they're going to be around for a long time. I wrote an article in the American Bar Association Journal oh God, when was that? Shortly after 91.
Yeah, early 90s.
Yeah, early 90s. And as I remember, there was 5 characteristics of common heritage of mankind that it was promoting. And all 5 of those characteristics pretty much makes your hair, you know, crinkle and fall out, as you can see. That's what happens. And it starts with that all nations must be involved, and all nations must have management authority, and all nations must receive the penalty if you break the treaty. And there's a couple other of them. Anyway, it's just a United Nations classic type of taking over the entire jurisdiction of the ocean. Anything else I can say?
Another question here?
No, Brad. This is Brad Blair.
I'd like to point out, or and then ask a question, point out that causality is difficult to determine between the Iridium and the Cosmos part of that collision. Iridium 33 versus Cosmos 2251, both of which were actually launched in Russia. By the way, and according to my understanding of the liability convention, it's the launching state that's liable, not necessarily the manufacturing state for the satellite. But due to the difficulty of determining causality, even between, let's say, a 1 centimeter bolt in the International Space Station, did the space station hit my bolt, or did the bolt hit the space station? And due to the assignment of liability in the liability convention to the nation that caused the problem, is there a need right now for changing, upgrading, or modifying that treaty, or creating additional structures in law that clarify that issue?
Right, if I can start just to give a summary, I agree that in the 67 Outer Space Treaty, it was the launching state, but back in those days, like, you didn't have the Russians launching a U.S. Missiles or satellites. So I think with the liability treaty, that changed a little bit to recognize it was the country that created the satellite that it becomes more responsible. I don't know if there's been any challenges to any of this. That would be an interesting thing, perhaps, in terms of...
Brad is very versatile in this and has done so much research on this, I can't tell you, but he is a recognized authority, and it's to add to the pool of knowledge that you carry around with you in your pocket. I think you asked the question because you thought maybe I could answer it. That's another reason for losing hair, by the way, so you can't answer it. But to point out more dramatically the difference, is it absolute liability, like from a launching state, or is it not something that a launching state did, but it happened in space, and so you have to determine who was at fault? Is that correct?
Yeah.
That's the issue.
But from a physics perspective, it's difficult.
No, I don't want to do that. I'm not legal. Let's look at it from a legal perspective. And so legally speaking, the causation, if it happened in space, depends on fault, right? Okay, that's not a scientific thing, that's a legal thing. But anyway, the solution to the litigation that I had mentioned earlier about using litigation to gather money together from the launching states to create a superfund is going to be based on strict liability, i.e. not on fault, because they're the launching state, okay? And then it is, it begs the question, is the damages that they would have to pay for, does that have to be caused with fault? Or does the launching state just automatically have to pay no matter what? And that's the harder question. Okay. And to solve that question, we've created a tort. We've recognized a tort that does not require something to come and fall on your head to be damages. Well, we've found a tort that is actively a tort, even though it hasn't happened yet, okay? And if I told you the magic word, you would say, I think you're right. So we're using this magic tort as the thing to bridge the gap so that if we're wrong, at least we become right again by introducing this tort that's magic, okay? And I'm keeping it as sort of a secret thing because we want to do more research on it before we file it, and as soon as we file it, then we'll tell you. If it worked, you know, if it works for us, it works for everybody. But this thing about debris coming up at a Mars Society convention is very important because everyone who wants to go to Mars first wants to leave Earth. And they might not be able to. So it's really a topic that cuts through the entire outer space activist community, no matter what part of it you're in, even the Planetary Society, who, you know, tend to think farther away than all of us, you know. But the litigation will be filed just before, it's going to be a Christmas present to the new president. Well, we're going to make it a Christmas present mainly because we don't want to file anything before the election, lest our lawsuit become a political football and then get deteriorated from there. But we're putting a lot of work into it, and I think it will work. We still haven't decided, nor, according to Brad, should we care to decide on who's to take down the debris. And that'll be decided probably a few years from now after we've gathered a lot of money. So by then, too, a lot of the technologies will have changed and there'll be a brand new landscape out there.
Exactly, and I still like the Swiss. I mean, they're the perfect people to go around and clean up outer space.
They clean up everything.
I mean, what other way to say, how can I make money in space low budgetly? A $10 million spacecraft to just clean up. That's a great idea. You just go shovel it up into the box and who knows where they take
This
it.
gentleman has a question here on my left.
So we probably have to stop.
You mentioned the gavel, and gavel can be for good and can be for bad. In light of international cooperation for the better, how do you see due process incorporated so that the results will bear cooperation versus litigation?
I didn't understand that question. Would you try that one again?
Yeah.
All right.
You said, you mentioned that the gavel, once the gavel hits, that's it. The verdict is in.
Yeah.
Now, the power of the gavel, it can be for the good and it could be for the worse.
Depending what side you're on.
Right, it could be, exactly. Yeah. It could be whatever side you're on, or it could be whatever the gavel is being hit by.
Yeah.
In light of that, so there's international cooperation versus international litigation. How do you incorporate due process that's been so fundamental in this country's development, where I came here because my parents brought me here because they didn't want to live in communism and what that was heading to. So I'm looking at it from the point of view, how do you view multiple countries working together in a legal framework where it's so complicated once it gets into the courtroom and you have to go through all the legalities and you know.
Well, all right, let me answer that. I think that's easy, now that I understand. And if I don't understand, don't worry about it. I'm good for half an hour on anything. Anyway, I think the problem that you're talking about need not really be a problem, because if we start litigation and it goes against us, then we dismiss that suit and sue every country in their own country. Or we appeal and go to a higher court. In other words, there's lots of sets of gavels out there. And the idea of due process really has no place in this argument. Due process is an American constitutional provision that relates to criminal law. And it's whether or not you can hold somebody, you know, in jail. And that's the reason for it. But these are all civil suits. And so I guess if you can afford to keep your lawyer in court, you can keep your lawsuit in court. It's one of those kind of things. Other than that, to amplify it even more, if you file that lawsuit and it gets any publicity at all, we'll be able to get America educated real fast on the problem. And from my earlier talks in a previous session, you know that I am interested in finding an outer space advocate, a member of our organizations, in the plural, who can run for president and last long enough to get into the presidential debates and then get the issues out on television 4 or 5 times, you know, throughout the United States of America and maybe a lot of the world. But that's a way I see of getting these issues that you and I are able to talk about in a small room with few people, to get it out there so that somebody else can get on board here and help us out, you know, and particularly and hopefully get a president of the United States who is an outer space candidate. I think that's so critical.
With that, we want to bring the session to a close. Again, we thank you for your attention. Again, please be aware that the International Space Development Authority, which we are part of, the Academy for Future Sciences, Ames, Universal, all are working on behalf of a new space frontier that we will bring free enterprise system into outer space, but also keep scientific integrity on the highest of levels. Again, we appreciate being here at this exciting time of the landing of the Mars Scientific Lab. I'm thinking of Jerry Soffin back at JPL many years ago with Viking 1 and Viking 2, and the excitement of looking at the possibilities of the evolutionary footprint, and now we've come a lot closer to it. So let's hope that we are going to see a new chapter, and with that, we bid you blessings for the rest of the conference. Thank you.